In today's enlightening episode, we will get into the intricate world of traffic stops, parking violations, and a crucially neglected topic, mental health. We will also shed light on the unseen connections between law enforcement encounters and individuals' mental well-being, exploring the profound impact these experiences can have on our society as a whole. In the fall of 2019, YouTuber, adventurer, and part-time delivery driver Mac Proctor, accompanied by his dog Bravo, parked their vehicle in an unauthorized area within a private parking lot outside an L&L Hawaiian barbecue in Millbrae, California. As per Mr. Proctor, the vehicle did not obstruct traffic, and he only left it there momentarily for 2 minutes while he picked up a carryout order from the restaurant. Upon Mr. Proctor's return to his vehicle, an officer from the San Francisco PD K-9 unit approached him regarding an alleged parking violation. The officer's name tag displayed the partial name C. Cord. We discovered a public pay log listing Officer Carlos Cordova, who was last promoted in 2019. Additionally, we located a photograph from July 2007 featuring Officer Carlos Cordova with the SFPD's K-9 unit, bearing a striking resemblance to the officer involved in this incident. Although we cannot confirm with absolute certainty that these two individuals are indeed the same officer, or that his name is Officer Cordova, we will refer to him as such throughout the remainder of this account for the sake of clarity. The video commences shortly after Officer Cordova halted Mr. Proctor and obtained his identification and vehicle registration documents. Mr. Proctor inquires if he is obligated to respond to any queries, and Officer Cordova assures him that he is not, affirming his ability to remain here indefinitely. Despite Officer Cordova's insistence that he can wait for Mr. Proctor to answer, he perceives Mr. Proctor's refusal as a sign of anger. Nevertheless, it is important to note that police officers are not legally permitted to prolong a traffic stop solely because a citizen declines to answer questions. In the case of Florida versus Royer in 1983, the U.S. Supreme Court ruled that while law enforcement officers are allowed to approach individuals in public areas and pose questions without violating the Fourth Amendment, the person being approached has the right to refrain from answering any questions. They are within their rights to ignore the queries and continue on their way, and they cannot be detained even momentarily without reasonable objective grounds. Simply put, their refusal to answer or listen does not provide sufficient grounds for detention. The framework for a traffic stop is somewhat more intricate compared to a street encounter, as outlined by the Supreme Court in the case of Illinois versus Caballas in 2005. The court established that a traffic stop, initially justified, can become unlawful if it exceeds the reasonable time required to complete its intended purpose. In the 2009 case of Arizona versus Johnson, the Supreme Court clarified that a traffic stop signals to a reasonable passenger that they are not free to terminate the encounter with the police and proceed as they wish. Even if the officer has finished the original objective of the traffic stop, the driver or passenger cannot assume that their detainment has ended and they are at liberty to leave. Consequently, the Supreme Court held that police officers cannot pose unrelated questions that noticeably prolong the duration of the stop. Regarding Officer Cordova's assertion that Mr. Proctor was angry, it is crucial to understand that exercising the right to remain silent should not be equated with anger. Furthermore, even if Mr. Proctor was indeed angry, he has the right to experience and express his emotions accordingly. With only a few exceptions, the First Amendment safeguards the right to freedom of expression, including negative emotions such as anger. In the 1949 case of Terminiello versus Chicago, the Supreme Court determined that the function of free speech in our system of government is to invite controversy. It may serve its lofty purpose best when it stirs unrest, creates dissatisfaction with existing conditions, or even incites anger. While it remains uncertain whether Mr. Proctor displayed anger during his interaction with Officer Cordova, it is important to recognize that all of his speech during the encounter was protected by the First Amendment, and he was well within his rights to express himself. Officer Cordova notifies Mr. Proctor that he is being detained due to parking in a location that is not designated for parking. However, the California Vehicle Code does not govern most parking infractions on private property, except for specific cases outlined in Section 22-500.1. These cases include parking in a designated fire lane, as stated in Section 22-500.1, parking without a proper placard in a space designated for disabled persons, as stated in Section 22-507.8, and parking without a valid decal in a space reserved for zero-emission vehicles, as stated in Section 2251.1. Furthermore, a 2011 opinion by the former California Attorney General Kamala Harris clarified that parking citations or notices can only be issued for illegal parking that violates federal, state, or local laws. Consequently, citations under the Vehicle Code cannot be issued for parking violations on private property that solely infringe upon the property owner's rules, but do not violate federal, state, or local laws. Although Section 211.07.8 of the California Vehicle Code permits cities and counties to establish ordinances or resolutions that extend specific portions of the Vehicle Code to privately owned parking facilities and public off-street parking areas, parking violations are not encompassed in the regulations applicable to private lots. Section 7.28.0 of the San Mateo County Code of Ordinances grants the Board of Supervisors the authority to impose necessary parking restrictions or prohibitions on streets, parts of streets, or county-owned property. However, neither the ordinances of San Mateo County nor those of the City of Millbrae address parking violations in private parking lots. Furthermore, Officer Cordova was not within his geographical jurisdiction as a San Francisco police officer when detaining Mr. Proctor, and it does not appear that Mr. Proctor was engaged in any unlawful activity that would warrant a citation. Officer Cordova expresses concern for Mr. Proctor's well-being, citing his behavior as hostile and implying the possibility of mental instability. The extent of mental health training received by police officers varies across departments and positions. In February 2011, the San Francisco Police Commission formed a crisis intervention teamwork group, comprised of individuals from the criminal justice system, mental health service providers, advocates, community members, mental health service consumers, and their families, as well as representatives from other city agencies. The aim was to develop new mental health training programs and field approaches. According to the San Francisco PD's website, 95.69% of officers had completed a 10-hour crisis intervention field tactics course, while less than half had finished a 40-hour comprehensive training course. These courses are based on the Memphis model of crisis intervention team training, which prioritizes de-escalation by allowing time and distance to address potential crises, thus enabling a slowed-down approach and giving individuals in distress the necessary space. The exact level of mental health training Officer Cordova received remains uncertain. However, it is evident that his accusatory questioning regarding Mr. Proctor's mental state did not contribute to de-escalation. Although the National Alliance on Mental Illness does list irritability or anger as common signs of mental illness in adults, it is highly unlikely that Officer Cordova could have arrested Mr. Proctor even if he suspected him of having mental illness. The authority of police officers to detain individuals based on mental health concerns is limited to situations where the person poses a danger to themselves or others, or exhibits severe impairment. Section 5150 of the California Welfare and Institutions Code states that a peace officer can detain an individual for up to 72 hours of assessment, evaluation, and crisis intervention if there is probable cause to believe that the person is a danger to themselves or others, or is severely impaired due to a mental health disorder. After the initial 72-hour detainment, Section 5250 of the California Welfare and Institutions Code allows for involuntary certification of individuals for up to 14 days of intensive treatment related to their mental health disorder or impairment resulting from chronic alcoholism. This certification can occur if evaluating professionals determine that the person poses a danger to themselves or others, or is gravely disabled due to the mental health disorder or impairment by chronic alcoholism, and if the person has been informed about the need for treatment but has not willingly accepted it. Given the stipulations outlined in the California Welfare and Institutions Code, it would be highly challenging for Officer Cordova to legally take Mr. Proctor into custody in this situation. Officer Cordova lacked probable cause to believe that Mr. Proctor had a mental health disorder or posed a danger to himself or others, and it was evident that Mr. Proctor was not gravely disabled. Upon being released by the officer, Mr. Proctor promptly initiated his vehicle's engine and departed from the scene without encountering any additional incidents. Mr. Proctor conveyed to us that he refrained from filing a complaint due to a compelling need to swiftly depart from the encounter, thereby preventing him from acquiring the officer's name at that moment. In general, Officer Cordova receives an F grade for his enforcement of parking violations on private property, unnecessary prolongation of the stop, and unwarranted questioning of Mr. Proctor's mental health due to his silence. Officer Cordova's strategy of intentionally delaying the stop because Mr. Proctor refused to answer questions goes against the court's intention to prevent such behavior, as established in the Tobias case. Multiple court rulings have concluded that officers cannot extend a traffic stop beyond what is necessary to fulfill its purpose. Unless an exclusive agreement exists between the property owner and the municipality, it is highly probable that Officer Cordova lacked the authority to issue a parking citation in the strip mall parking lot. Furthermore, valid concerns arise regarding whether the officer was operating within his jurisdiction at the time. Had Officer Cordova genuinely witnessed Mr. Proctor's vehicle obstructing traffic, the appropriate action would have been to inform Mr. Proctor of the obstruction and request him to move, rather than initiating an investigative detention in a private parking lot outside the department's jurisdictional authority. Officer Cordova's unprofessional behavior and immature exercise of authority tarnished the credibility of his mission to alleviate parking lot traffic obstruction. Such conduct only serves to undermine public confidence in the local department. Mr. Proctor deserves an A+ for peacefully and efficiently asserting his right to remain silent, refusing to allow the officer's behavior to emotionally affect him, and maintaining a calm and collected demeanor throughout the interaction. Accusations of mental instability, particularly when made by individuals in positions of authority, carry significant implications. Most people cannot predict their reaction to such allegations, and it is reasonable to assume that there is no appropriate response in such a situation. Strongly denying the officer's claims might have further validated the officer's suspicions, while admitting to feeling agitated and angry could have raised officer safety concerns. Therefore, Mr. Proctor's decision to unwaveringly remain silent and composed was the best course of action in this encounter. It is worth noting that Mr. Proctor is not a First Amendment auditor, and although he has a YouTube channel, the majority of its content is unrelated to law enforcement. The fact that Mr. Proctor does not frequently interact with the police highlights his ability to stay calm and navigate the encounter with precision and composure, which is even more impressive. The only aspect lacking in this interaction is accountability. However, it is difficult to blame Mr. Proctor for not filing a complaint, considering that he is not a First Amendment auditor and does not actively engage in holding officers accountable. We commend Mr. Proctor for demonstrating an excellent balance in exercising his right to remain silent and for remaining composed and peaceful throughout the encounter. Thank you for joining us in today's episode as we explored the complex world of traffic stops, parking violations, and the crucial topic of mental health. If you found this content informative and thought-provoking, please consider giving us a like and subscribing to our channel.